Well, good morning. Good morning. It is early for me. This is Laura, the real LauraB, here on YouTube and on Twitter. And I have a surprise filing today in the appeal. The Amber is appealing against Johnny, that big, huge 16-point throwing everything but the kitchen sink at the wall. Yeah. We have an answer today from Depp team against, it's a full omnibus collective opposition answer to the Amicus Curiae. And that's what we're doing today. So hang in there.
Hi, I'm Laura, also known as TheRealLauraB from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer, nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
Again, welcome back. Welcome back. Yeah, we have a scathing answer from Ben Chu from the Depp team. Remember, Amber Heard's friends of the court filed two Amici briefs or Amicus Curiae Briefs. Huge, big PR stunt. I didn't cover them. A lot of the law tubers did. Good for them. I felt it got enough airtime. It got enough attention, and I wasn't giving it anymore because it was very much a PR stunt. It was a whiny bunch of people having fits that we don't like the jury verdict. We want it our way. We don't like what the jury found, and I wasn't just giving into that. So this is going to be the answer. I did not get this. Larry Foreman from DUI Guy did. He shared it with me. Thank you very much, Larry. I'm putting his video in the bottom. He did one last night. Very energized. I'm a little bit more sedate this morning. But I don't have the link to share. I have the document, but I don't have the link to share. So I think the best thing to do, I've got the kitties showing up anytime this morning. So I think let's just get started. Can I make this bigger for you guys? Oh, that's interesting. I went in the opposite order. So let's see. Doesn't look like I can make this a lot bigger. Hold on, guys. Let's see if I widen it. Does that make it? Okay, so this is in the appeal Amber has filed against her loss. She had 16 points. She came in with all 16 points, but this is the omnibus or a collective opposition to the Amici briefs that were filed. So let's get started. Appellee John C. Depp, or Mr. Depp, by and through his undersigned counsel, respectfully submits his omnibus opposition to the motion for leave to file brief of Amicus Curiae Sanctuary for Families, the Virginia National Organization for all these people, and the motion to leave to file amicus brief filed for the Amici by Fletcher. To avoid burden in court, the duplicate briefing, and because the issues overlap, Mr. Depp addresses both motions in this opposition. So this is opposition to both amicus briefs at the same time. This is a kitchen sink appeal, with appellant purporting to assert no fewer than 16 assignments of error. Appellant Laura Heard, Ms. Heard, who is represented by two large and well-regarded law firms, is seeking to relitigate virtually every major ruling made by two distinguished and highly respected chief judges of the Fairfax County Courthouse, the Honorable Bruce D. White, retired, and the Honorable Penny Z. Escarate, over the course of a 3-year litigation and 6-week jury trial. In addition to the oversized brief of 55 pages that Ms. Heard has filed in support of her appeal, the Amici seek to present a collective 93 pages of additional argument in support of Ms. Heard's position. If the motions are granted, Mr. Depp will be required to respond to a total of 148 pages with his own brief, which presently is set at 55 pages. So normally it's 50 pages. We know Amber Heard asked for an extension of time. She asked for 60 pages. The court gave her an extension of 23 days, and gave her 55 pages. Depp then filed for his own extension. The court stated and said, we're not going to rule on it yet because we need to have the exact date that she files to count our dates off of. So they couldn't say, we're going to say your response is due by XYZ date. We have to say it's going to be so many days after she responds. She responded. So now he's set for December 23rd. Hopefully that'll get extended. He was to get 50 pages. It's presently set at 55. So I'm guessing they've done some kind of ruling on, well, the number of pages at least, and probably the extension. Though there are doubtless cases in which briefing by Amicus Curiae might assist the court in resolving the issues before it, this is not, emphasis underlined, this is not one of them. Mr. Depp respectfully submits that the filing of such extensive additional briefing by Amicus Curiae here is neither necessary nor appropriate and should not be allowed. As a threshold matter, the court should deny their motions because the amici failed to comply with the applicable rules by inter alia, neglecting to properly assign error, which violation constitutes sufficient grounds for denial. Moreover, Ms. Heard is very competently represented and is not in need of assistance or additional briefing in support of her position. Nor should Mr. Depp be burdened with having to respond to such voluminous additional briefing. Finally, the amici's arguments add nothing to the legal analysis provided by Appellant Heard's counsel and appear focused instead on arguing with the jury's clear finding in favor of Mr. Depp on the underlying factual issues. The amici proceeds from the essential premise that Ms. Heard is a representative of domestic abuse victims, a premise that was emphatically and soundly rejected by the jury, who paid careful attention to the evidence presented during the 6-week trial. Both amicus briefs cherry-pick evidence that they believe should have swayed the jury to a different finding, but offer the court no insight on the legal issues actually at issue in Ms. Heard's appeal. Allowing this additional briefing would merely serve to complicate what is already a sprawling, misplaced appeal. Accordingly, Mr. Depp most respectfully notes that the court deny the Fletcher and Simpson motions. So that's one of them. Oh, no, both of them. Footnote, it bears noting that the trial court rejected a motion to file an amicus brief at the pleading stage of the case for many of the same reasons that the motions should be denied here, with then Chief Judge White noting on the record that Ms. Heard's counsel in the case are highly experienced and would present the law quite adequately to the court, while rejecting the suggestion that the trial court, in ruling on this specific case, should take the amici's policy goals into effect, as opposed to really, in this case, on what the law already is in the Commonwealth and the evidence of the facts that I hear. Before we get into the argument, let's think about what's going on here. In an appeal, Amber Heard files her motion, 55 pages. Mr. Depp files his reply, opposition, 55 pages. Ms. Heard files her reply to Mr. Depp's opposition, I think it's 15 pages, and that's it. Then maybe they get a hearing. These amici briefs come in with combined over really 100 pages that Mr. Depp has to answer. He's also filed some of his own assignments of error. But this now gives a chance for Depp to speak to the judges again, separate from his 55-page reply. He gets to highlight the fact that, hey, we won. The jury found in favor on all 3 of our issues. He gets to highlight that again to the judge. So I'm not sure if this may have backfired on them, since it was just a whiny PR stunt to start with, in my opinion, and many law tubers' opinion, but it gives him a chance to speak again to the judges. And I think that Amicus Curiae that was filed in Virginia was filed by the Press Association. I have to look it up again. That they, and I think they had an early one, friend of the court. Let's see if we can find it real quick. This just happens when I get a cold reading. With a crazy person, Virginia Press Association. Yeah, Virginia Press Association, and it was denied. It was denied. The argument. The court should deny leave because the amici failed to comply with the applicable rules. The amici failed to comply with the rules, to wit, a brief amicus curiae must comply with the rules applicable to the brief of the party supported. Because the amici are seeking to support Ms. Heard's opening brief on her appeal, they are required to comply with all of the requirements set forth in Rule 5A20, including the requirement that the brief must contain a separate heading for assignments of error, with a list of the specific errors claimed to have been made by the trial court, and an exact reference to the pages of the record and where the error has been preserved. A failure to assign error or insufficiencies in the assignments of error are both a basis to dismiss an appeal, as is the failure to adequately support an assignment of error with citations to the relevant pages of the record. Here, neither the brief offered by Simpson amici nor the brief offered by the Fletcher amici complies with these express requirements. And they're citing the lawyers, I think, who wrote it because they're so incumbent. In fact, I don't even think we knew who the other people were. The Fletcher amici brief does not contain a section of assignments of error at all, while the Simpson amici included a separate section for assignments of error, but failed to support it with any citations to the record. In addition to their failure to provide any supporting citations, the Simpson amici also violated the rules by using a size 12 font rather than the required 14, meaning their brief is actually even longer than it appears to be on the face. Based on the clear violations of the rules, the court should deny their motions for leave. Yeah, they're very strict about how many pages, the spacing, the font, the typeface. They're very, very strict about this. It's all got to be uniform. The court should deny leave to file the briefs because appellant is well represented and responding to the amici would unnecessarily burden Mr. Depp. This is really concerning because I didn't think about this. Subject to exceptions not pertinent here, a brief amicus curiae is permitted only on motion and by consent of this court. The rules therefore reflect that such briefing is generally considered unnecessary, nor would it be necessary or helpful in this case. It is undisputed that Ms. Heard is well represented in this action by two major law firms, Ballard Spahr and Woods Rogers, Ventnor Black Woods Rogers, which also acted as Ms. Heard's co-lead trial counsel. On behalf of Ms. Heard, Woods Rogers and Ballard Spahr have already filed an oversized brief of 55 pages that seek to put to issue 16 separate assignments of error, emphasis added, italicized. Take note, judges. This seeks to put an issue for 16 separate assignments of error. And I think they're doing this when my understanding is when these things are filed, the appeal brief gets filed, it goes into a folder, so to speak, virtual folder, Depp's reply, opposition, then hers. When it's all complete, it gets put to the judges. When these, I don't know what happens with these amici curiae because they're supposed to file leave to allow us to do this. And then Mr. Depp has to answer it. I'm thinking that the judges will have to rule on this separately and soon because it has to be part of his reply. So now he's getting ahead of the line in front of the judges, my guess is, because this has to be ruled on. He has to know what he's replying to, what he's opposing to. She certainly does not need 93 pages of additional supporting brief from outside amici, as noted above in light of Simpson amici's use of smaller font. The actual page of extra briefing is closer to 100. To adequately present her arguments to the court. Moreover, Ms. Heard's counsel appeared to be acting in coordination with counsel for the amici, which strongly indicates an attempt by Appellant Heard to circumvent the page limits imposed on both parties. And this was mentioned by a lot of law tubers, that this might be used to supplement her opposition, playing the game a bit by getting some extra pages in. For example, in the proposed amicus brief offered by Simpson amici, which was filed and served the same day as Ms. Heard's brief. And let's also note that she asked for an extension of time, and it just so happens both amici briefs came in the same day. Ms. Heard's opening brief, Ms. Heard's entire statement of facts is simply incorporated by reference in an open acknowledgement. Then the amici had previously received Ms. Heard's brief and were acting in coordination with her counsel. That shouldn't go over well. That's playing the game, I think. And I think these judges know this and they're aware of it and they're used to it and they see it. Mr. Depp, who has received leave to file a brief of only 55 pages, here we go, but I don't know what the due date is, would be unnecessarily and unfairly burdened if the amici briefs were allowed. Mr. Depp must already respond to Ms. Heard's highly unusual 16 separate assignments of error in a single brief. Further, Mr. Depp must also address the 3 additional assignments of error he identified for the court's consideration in the event of remand. He has to include that. He has to put it all on the table. Let's not let this worry us. If the amici briefs were allowed, Mr. Depp would also be forced to address their 93 pages of argument, totaling 148 pages, all in the same responsive brief. The burden on Mr. Depp of doing so would be substantial and unjustified. The court should deny leave because the arguments of the amici are irrelevant and inappropriate. Mr. Depp will not address the substance of the amici's arguments in detail in this opposition, other than to point out that the arguments in their briefs are for the most irrelevant to the legal issues on this appeal and consist largely of disagreements with the jury's factual findings or complaints about the impact of the jury's factual findings on society in general. The amici cherry pick and misstate evidence that they maintain supports their personal factual conclusions to argue that the jury got the factual issues wrong, while ignoring the substantial evidence, including testimony of credible disinterested witnesses, that was presented to the trier of fact, the jury, of Ms. Heard's abusive conduct, admissions, and copious lack of credibility. The amici also expend many pages arguing that the jury's verdict is somehow harmful to abuse victims in general. Such arguments are wholly inappropriate on appeal. This court should not substitute its own judgment, must list the judgment of the Amicus Curiae for that of the jury. We do not substitute our judgment for that of the trier of fact. Likewise, the amicis focus on some perceived social harm that results to abuse victims generally from the verdict is both factually misguided, because the jury clearly and emphatically concluded that Mr. Depp is not, emphasis added, italicized, Mr. Depp is not an abuser, and an inappropriate argument because the jury was tasked with making a factual determination with respect to only the parties to this action, not with sending a message to society at large. That's a big point. That is huge. This was Johnny Depp versus Amber Heard, not Johnny Depp versus all women of the world. Closing argument asking a jury to send a message to society in general was improper because of its tendency to inflame a juror's prejudices and to divert the juror's attention from the evidence produced at trial and focus it upon extraneous and admissible errors, which they did in closing. Heard's team did that. And the jury said, no, this is not to be a public matter. In this context, it would be unfair to force Mr. Depp to use some of his limited pages in responding to this extraneous arguments. Moreover, the back and forth between Mr. Depp and the amici on these non-issues would be a distraction and add nothing to the court in assessing the actual legal issues before it is appealed. I am wondering, when he says a back and forth, if the amici, if in Johnny's opposition, if the amici again get to file a 15-page reply. I don't know. We're going to have to check with Rob with Law and Lumber because he is a Virginia lawyer and he would know these things. Yeah. Conclusion. Based on the aforesaid, the court should deny Miki's motion for leave. So what do we have in addition to this? They did file a little precipice. Amicus Curiae in support of Appellant Amber Heard. This is the very next day. And reversal of the judgment hereby filed a supplement to corrected brief. I don't know if they can do that. Although amici do not believe that assignments of error are required for an amicus brief, amici provide information as to which of the arguments apply to specific assignments of error identified by Appellant Amber Heard to assist the court in its review of the case. So they sent in some exhibits of their revised table of contents with the assignments of error, assignment by the appellant. Yeah, so they put in something quickly last minute. I don't know if they're allowed to do that. Here are the Depp filed. I know it's small. I don't think I can make it much bigger. This was his additional assignments of error. The trial court erred in denying Mr. Depp's motion to deny Ms. Heard plea and bar with respect to anti-SLAPP immunity and in denying Mr. Depp's motion to summary judgment with respect to Ms. Heard's anti-SLAPP defense. And it was preserved. Which motion the parties argued on January 29, 2021, and the trial court denied on March 21st, 2021. Plaintiff's memorandum in support of motion for summary judgment as the defendant's anti-SLAPP immunity, which motion the parties argue and the trial court denied March 24th. This is a just in case. Worst case scenario, if you just send us back to trial, she can't claim anti-SLAPP. We don't want her to be able to do that. This is worst case scenario, guys. They got to get it on the record. Which motion the parties argued and the trial court denied March 24th as further reflected. So they're going to have to further argue this in their reply. The trial court erred by excluding the expert testimony of Dr. Kimberly Collins, a forensic pathologist retained and designated by Mr. Depp. Yeah, she had a lot to say about the injuries, the horrific injuries Amber Heard claimed throughout her, not just her testimony, but in her declarations filed April 2019 about these horrible things that happened to her. She just never showed the injuries to match the allegations she made, according to Dr. Kimberly Collins. The parties argued about the admissibility of Dr. Collins' testimony. Mr. Depp also made a proffer before the trial court on this issue. She was, apparently they decided she was only designated as an expert witness, and because Ms. Heard did not call her own medical, what do I want to say, versus Dr. Hughes, physical medical doctor, they wouldn't allow Dr. Kimberly Collins in as a rebuttal expert. In this one, the trial court erred in overruling Mr. Depp's objection to jury instruction C, which required a finding that the statement was false. Instead of adopting Mr. Depp's proposed edit, required a finding that the defamatory implication of the statement was false. And B, denying Mr. Depp's request to conform the special verdict form to instruction C, which was given to the jury over Mr. Depp's objection. I don't think I have the whole thing here. And in support of the objection to improper argument and motion for a curative instruction and revised special. So again, this is in case remanded, in case it goes back to trial. He wants to make sure that we don't go by the same jury instruction, that anti-slap doesn't come in, and we get to bring in our expert witness. So the statement they didn't like was under C. They noticed C specifically, right? Instruction C. You shall only return your verdict for Mr. Depp on his claim for defamation about the following statement if he has proved by the greater weight of evidence that. So they wanted to say that the defamatory implication of the statement was false. Because just because she said she became, I spoke up against sexual violence and faced our culture's wrath, this has to change. Whether she said it or not could be confusing because she adopted it. Remember, she republicated it. And that's how they're saying that she owned it because she republicated it. They're saying it should be that it implicated him. And I think that's it. I think that's what I got for today. Yeah, it was the opposed motion of the Virginia Press Association for leave to file Amicus brief, and this was denied. This was denied back then. They were going in there, I think, with free speech. So that's what we've got today. It was a quickie filing. I'm glad I could get a video up on it. Larry did his last night. I will link it out down here. I don't have the document to share. It's not mine to share. It's up to him. But yeah, I'm curious about the law tubers, how this gets more information to the judges, because it really was a ridiculous, I don't like the verdict. It's not what we were hoping for. It does, we want to hang our hats on that all women are to be believed and women can't be abusers and only men can be abusers. And if they're accused, even if they're not guilty, they just need to lay down and take it. They just need to accept it on their back and have their entire life ruined just because they were accused. And we're seeing far too much of that. We're seeing that in the media. Even after this verdict, 7 jurors unanimously, they had to be unanimously found that she was liable in 3 statements with actual malice, meaning she knowingly lied. This is really different with what they're arguing, because she is the first person. This happened to me. This isn't a journalist saying, I saw the TRO records, I heard from her, I read her story, whatever. So I'm taking her position that what she's saying must be true and I'm going to report on it. No, this is the first person saying this happened to me. And they're saying, no, it didn't happen to me. They're saying it didn't cause him any damages. The op-ed didn't change his career. And we had, I think it was Banyat said that in his expert statement said, no, this letter was this op-ed was a first person writing saying a call of action. Don't work with him anymore. Don't work with any of these men anymore, but don't work with him. That's what the op-ed, that's what the expert said. So, yeah, so I don't know what happens next, because I don't know if he's only limited now to 55 pages or if we're going to get more of this back and forth on the Amicus Curiae Briefs. So that's it for today. Ben's pissed, fiery, well written, to the point. Got a lot of information to the judges maybe they would not have known about. And that's all I have for today, guys, because I've got kitties showing up in about 10 minutes. Have a good rest of your day. Take care, and justice for Johnny Depp, always.